You look lonely up here.
Normally, Your Honor, I would ask for rebuttal. Thank you, Mr. Chief Justice, and may it please the Court. Christopher Baum for the Attorney General. This Court held in 2007 that it has jurisdiction to issue an advisory opinion as to the validity of a financial impact statement. That decision was correct, and stare decisis principles counsel in favor of adhering to that decision. It has proven workable. Receding from it would dismantle the legislature's mechanism for reviewing financial impact statements, and the recent amendments to Section 100.371 do not undermine its premises or cause that decision to be unworkable.
Well, let's just go back to, let's put aside this stare decisis standard and look at whether the decision that we've made previously to exercise jurisdiction in this context is correct. I'm not saying we shouldn't go through some analysis after that, but I'm having a hard time seeing how what we've decided to do in this context is correct. When I go to Article 4, Section 10, which refers to our rendering an opinion as to the validity of any initiative petition, I'm struggling to see how we get from that core language that establishes our jurisdiction to an opinion regarding the financial impact statement, which is not part of the initiative petition. Now, we could have a system where initiative petitions had to have a financial impact statement. That would be a different system than the one we have. And I think there would be an entirely different issue there, because if it's part of the initiative petition, then I think it would be a very strong argument that it would, rendering an opinion on the validity of the initiative petition would encompass the financial impact statement that was part of the initiative petition. But that's not what we have. So we have something separate that tags along afterwards. Actually, it's a separate case, separate matter. And I'm just struggling to see how we can be faithful to that language that establishes our jurisdiction and act in the way that you're suggesting we should. So tell me what I'm missing about that language.
Sure. Well, respectfully, Your Honor, Article 4, Section 10 does not establish this Court's jurisdiction. In fact, Article 5, Section 3B10 is the jurisdictional provision that sets forth the scope of this jurisdiction. And that section provides that the Court shall address issues as provided by general law. Now, there's a cross-reference to Article 4, but Article 5 is the jurisdictional provision. And the fact that Article 5... But
doesn't it all lead back to Article 4, Section 10? I mean, that's the basis for everything we do in this arena. Because, I mean, right there in Article 5, Section 3B10, which is what you're referring to, it specifically refers to Section 10 of Article 4. So that's there. That's part of what we're talking about when we look at our jurisdiction.
Yes, Your Honor. I think that the cross-reference is exactly that. I think that Article 4 establishes that the Attorney General may request an advisory opinion on that specific topic, but it does not limit what the Court may address in issuing an opinion on that particular topic. In other words, the Attorney General may not simply ask for an advisory opinion on anything. It has to be with respect to initiative petitions. But the Court has a slightly broader grant of jurisdiction in Article 5, Section 3B10, because it shall render an advisory opinion addressing issues as provided by general law.
Aren't you leaving out some important language? Doesn't it say, shall, when requested by the Attorney General pursuant to the provisions of Section 10 of Article 4, render an advisory opinion?
So that refers to the Attorney General's request. So
right.
The request must be...
Pursuant to. But that's limiting language on our jurisdiction. The request must be pursuant to the provisions of Article 10, Section 4. Do you agree with that?
I would agree that the request must be made pursuant to Article 4, Section 10, but that does not limit what the issues the court may address are. It just simply says that the request has to be made.
But then referring to Article 4, Section 10, it says the Attorney General shall request the opinion of the justices of the Supreme Court as to the validity of any initiative petition.
So that's what the Attorney General must ask for, and then the legislature can pursuant to Article 5.
So if our jurisdiction is limited to a request made pursuant to Article 10, Section 4, and Article 10, Section 4 says that the Attorney General shall request an opinion regarding the validity of the petition, why isn't that the limiting language on our jurisdiction?
Well, that's one way to read it, and that's certainly the way that Justice Bell read it.
Isn't that the most reasonable way to read it?
Your Honor, I think it's one way to read it, but another way to read it would be that Article 5, Section 3B10 does not contain that similar limiting provision that the issues must relate to the validity of an initiative petition.
Why would it need to repeat there what it has said elsewhere, what the Constitution has said elsewhere?
Well, it would certainly be more clear, Your Honor. I don't think we'd be here today. One
never knows.
But an additional issue is that the court has already held repeatedly in Roberts versus Brown in the term limits pledge case that the court's jurisdiction is not limited to addressing the constitutional validity of an initiative petition, because otherwise the court could not review the ballot titles and summary for compliance with 101.161.
Do you agree that either under the Constitution, as Justice Bell said in his dissent, or even the statute, even beyond that, that the validity of the petition itself is not dependent upon the validity of the financial impact statement?
Yes, Your Honor. And I think that if the jurisdictional provision is read to preclude an assessment of the statutory validity of an initiative petition, then, and it would be limited only to the constitutional validity of an initiative petition, then the court could not review ballot titles and summaries.
Under our current system, aren't the ballot titles and summaries part of the initiative petition?
Yes, but the only constitutional requirement as to the validity of an initiative petition is the single subject rule. So if the court's jurisdiction is limited to the constitutional...
But that's where it does say as to the validity and then as directed by general law. So we're talking about the validity of the initiative petition, which includes the ballot title and summary, and there is opportunity for the legislature to define within those parameters what our review is. The problem is, I think you would agree, you already did with Justice Kennedy, that the financial impact statement is not part of the initiative petition.
That's correct, Your
Under
Honor.
our current system.
That's correct, and I think that to the extent that the court is inclined to agree with Justice Bell's reading of these two constitutional provisions, then this is a stare decisis case. And referenda required for adoption has proven eminently workable. The court has approved 17 out of 23 of the financial impact statements it has reviewed. It has rejected 6. All 6 of those have been cured. The court has accepted 10 out of the last 10 financial impact statements. So the conference has not struggled in drafting these statements, and the court has not struggled in reviewing these statements. So the decision, and the court
we wouldn't struggle in reviewing a lot of things that we don't have the authority to review.
That may be true, Your Honor, but the decision has not proven unworkable, which is part of this court's test.
Isn't it sort of structurally unworkable that the court is acting outside of its constitutional authority?
That's only if this court disagrees with the 5 justices who held in referenda required for adoption that it was acting within its constitutional authority. And that question turns on principles
Don't we
of stare
always
decisis.
treat jurisdiction a little differently? I mean, we can raise it on our own initiative. It doesn't have to be preserved. We can look at it at any time. I mean, it's a pretty fundamental error for a court to act outside of its constitutional authority, isn't it?
Absolutely, Your Honor, but I don't think that there's any principle of stare decisis that treats jurisdictional holdings any different from any other type of holding.
Well, why shouldn't there be? It strikes me that an error with respect to the exercise of jurisdiction is in a category of the most serious errors that a court could make. Wouldn't you agree with that?
That may be so, Your Honor. However, there may also be other types of holdings that the court could issue that could be of great magnitude.
Well, I wouldn't disagree with that, but I'm not saying that it is at the necessarily alone in being a serious error. But I mean, it's just kind of axiomatic that acting for a court to act outside its jurisdiction is just goes against the grain in a dramatic and fundamental way.
I certainly agree, Your Honor, but we have 5 justices in referenda required for adoption who held that the court was acting within its jurisdiction.
I read what they said, and they did not talk much about the Constitution. Did they?
Well, they certainly referred to the applicable provisions here.
It seemed more they were talking about the statute. And there's no question that the statute contemplates that we do this. But that seemed to be the focus of their analysis.
Yes, Your Honor, and that was because the court read the language addressing issues as provided by general law in allowing the legislature a little bit of leeway in giving this court jurisdiction to address questions that are related to initiative petitions. And so then the court turned to whether the legislature had in fact done so, and the legislature, of course, has done so in 100.371.
As a practical matter, if there's really a problem with the impact statement, someone could challenge that in a declaratory statement and bring it through the trial court process if we don't have jurisdiction to address it in an advisory capacity, right?
Well, there's certainly a question about that, and Justice Bell opined that that may be a possibility. But the current structure of Section 100.371 presents some problems because it sets forth what happens if this court specifically were to reject a statement, then it would be remanded. Or if this court did not act in time, then the statement would be deemed approved.
Well, even if hypothetically a DEC action was brought and then it found its way to our court, then those provisions would still apply. So I don't think they're necessarily in conflict, would they be?
I think that's right, Your Honor. I just think that there's an outstanding question over whether a court of original jurisdiction could address this. I don't think it's a settled issue.
Are there any provisions in the statute that explicitly prohibits that kind of action going forward?
Not necessarily, Your Honor, although the court did hold in Roberts v. Brown that this court has exclusive jurisdiction to review ballot titles and summaries and perhaps by extension financial impact statements. But I think that you're right that if this court were to hold that it did not have original jurisdiction over financial impact statements, then a trial court may have jurisdiction. But I would hesitate to opine on, for example, who would have standing to bring such a challenge, as it is the Attorney General in this instance that provides, pursuant to the Constitution, that she may bring such a petition. But in all, I think that this is a stare decisis case, and perhaps the court may elucidate a new standard with respect to jurisdictional issues, but I think that the stare decisis factors here counsel in favor of adhering to referenda required for adoption.
I mean, without getting into the whole stare decisis quagmire, I mean, I think our most recent case on stare decisis essentially just said if there's a clear legal error, then we'd proceed. I mean, I think you might be overstating our quote-unquote stare decisis test. Obviously, there are cases where we purport to apply the multi-factor Planned Parenthood type test, but there's also very recent cases where we don't talk about that test at all.
The state of the court stare decisis test is a little unclear, but we've relied on what the court has said with respect to that 3-factor test. Although I would note that the court has said in the context of advisory opinions in particular that while they might not be in a highly technical sense binding, they are highly persuasive and only to be overturned in, quote, extraordinary circumstances. And the only circumstance in which the court has done so is in a case where the prior opinion did not squarely address the issue in that case. Now, for example, here, in referenda required for adoption, in dissent, Justice Bell noted in footnote 8 that had the court opined on jurisdiction, it would be binding. So I think that it might even be a higher standard in the context of these advisory opinions to the Attorney General.
Well, the reality is that these advisory opinions are not really advisory opinions.
Correct.
I mean, it's not to criticize our Constitution, but it's really a misnomer, because what we decide determines whether it goes on the ballot or not, and determines whether with respect to the financial impact statement, decides whether that's going to go on the ballot or not, right?
That's correct, Your Honor, and that's what the court said, I believe, in Roberts versus Brown, said that these decisions are highly consequential. And so I think that even if the court were to recede a little bit from its stare decisis principles outlined in the Valdez case, the three-factor test, I think in the advisory opinion context, the court has said that it would recede only in extraordinary circumstances, and I don't believe that we have those here, because the decision has proven workable. Although it would not cause serious injustice to overturn it, the court has relied on it in 13 subsequent decisions. The legislature has a finely wrought mechanism for the court's review, and the recent amendments to Section 100.371 do not undermine that decision and do not cause this court's review to be unworkable.
Yeah, I mean, I think it seems like to me the stronger argument would be that to acknowledge some ambiguity, and essentially the legislature has made a determination that we have jurisdiction. And I mean, don't we have a zillion precedents saying that, something has to be clearly I mean, we essentially would be saying that the mechanism the legislature has set up is unconstitutional. And aren't we supposed to give the legislature every benefit of the doubt when they've interpreted the Constitution?
I think that's certainly one way that the court could look at it, yes, and especially in light of the jurisdictional provision containing the language regarding general law. Now, elsewhere in Article 5, for example, that term denotes discretion on the legislature's behalf to define the scope of the jurisdiction of courts. For example, the district courts of appeal, the circuit courts, the county courts, et cetera. So I think that's correct, Your Honor. So unless the court has any further questions, we would argue that referenda required for adoption should be adhered to on the basis of stare decisis.
We thank you for your argument, and that concludes today's session of court. Stand in recess.
All rise.